My background, I clerked for Ab Mikva and William Brennan, and then I represented Al Gore in the 2000 election litigation. I don't come to bills like this with sort of a presumption that there's got to be something wrong. But I have to say, the more I studied this bill, the more remarkable it became to me. And it is truly a wolf in sheep's clothing. It is not an arcane technical bill that should sort of glide through Congress in a non-controversial way. It is a radical bill. It reverses over 2 centuries of American law, and it does so in a way that's startling. For example, one of the things Kevin mentioned was how hard it would be for small inventors to win the race to the patent office when they're racing against a big company. Aside from that systematic discrimination, the bill also tightens the rules that govern something called a grace period. If you're a small inventor, you will not be able to afford the entire patent process and the commercialization process on day one. The way the world works is small inventors and universities and nonprofits and independent research organizations that have an idea engage in a dialogue with investors, venture capitalists, potential partners. The process goes back and forth. In the current law, people have what's called a grace period that protects them from having confidential discussions with investment partners, so that you develop an idea, you go to a potential venture capitalist, you say, here's my idea, what do you think? And the venture capitalist says, well, you know, that's a great light bulb, but we need a little bit more. Here's a little bit of money, go try to make a prototype, try to figure out how to make it better. The process goes back and forth and back and forth. At places like in Boston at MIT, there are rooms where potential inventors meet potential VCs, venture capitalists, and these dialogues take place. The bill tightens those rules. It makes it very hard for inventors, especially small inventors, who don't have the in-house advantages of an Intel or a Microsoft. It makes it very difficult for them to attract financing, because it says it provides that these sorts of public uses and disclosures will be held against them and can disqualify them from getting a patent. Without getting into the technical words, here's the reality. Under this bill, if this bill had been the law in the 20th century, the Wright brothers would have been disqualified from their patent. Hewlett and Packard, whose main invention was something called an oscillator, would have lost their patent, would not have been eligible. This is a big change in law. It's a change in law that is contrary, as Adam said, to the understandings of Thomas Jefferson, James Madison, John Marshall, who was the first great Chief Justice. And so it's not something that we should undertake lightly. There are certain provisions of the Constitution, like due process, equal protection, even Congress's commerce power. Those are broad provisions. They have a lot of latitude. And they require all sorts of judicial elaboration. The constitutional provision here is not like that. It's very specific. It says Congress must secure patent rights to the inventors of discoveries. And that's why, as Professor Mossoff said, that's why it's unconstitutional. And I'm really here to talk about a hidden section of the bill that's escaped a lot of attention. It's called Section 18. What Section 18 does is create a special review provision. Basically a special way for people who are accused of patent infringement from knocking out a patent. But it does so not for everybody, but only for financial services institutions. Everybody else in the world today already has several opportunities in court and at the patent office to say that a patent is invalid. So if you are running a business and somebody sends you a letter saying, by the way, you're infringing my patent, you have remedies of going to the patent office to have that patent declared invalid, or you can go to court and defend an infringement action, or you can bring an action of your own and say this patent is invalid. This bill, though, singles out banks, surprisingly. Banks that we've seemed to have been in the news a lot the last few years, gives them another special benefit. It's really special interest legislation, again, another bailout, because it allows banks it creates a whole provision that's just for them to knock out the patents that they think infringe on certain business methods that they might use in providing financial services. This provision is problematic for several reasons. First is it's retroactive. So patents that were issued years ago have already been approved by the Patent Office, in some instances, perhaps several times, past examination, re-examination. Maybe they've been involved in litigation and they've been held to be non-infringing by a court, and valid patents by a court. Those patents, once again, can be attacked through this special provision of Section 18. Section 18 is problematic for international trade reasons, because under our international trade agreements, the United States is prohibited from granting special rules for intellectual property to certain industries. And we complain very much when China and other trading partners don't respect intellectual property. And Microsoft, in fact, has sent a letter and protested this provision of Section 18 on the ground that it violates U.S. commitments in its international agreements. It also raises constitutional problems of its own, because patents are property. That's one of the sort of black letter understandings of what the Supreme Court has held for 2 centuries. And if government interferes with your property rights, it creates a taking. That's a taking of property, whether it's a highway through your front yard or whether it's a confiscation or interference with a patent right that you may hold. And this creates a problem, a fiscal problem for the government, because if the government takes a patent, then the government is financially liable to pay compensation for that patent. And the financial services industry tried this gambit, a provision like Section 18. They tried it in 2007, and the Congressional Budget Office said that that attempt triggered a financial obligation. It scored the bill, in the parlance that you all use, but said it would cost the government money because the government would have to pay compensation for a patent that the government interfered with. And that the scoring of the bill in 2007 sort of killed it, because under a PAYGO system, you're going to have to identify how you're going to pay for that taking, and nobody wanted to do it. But the same logic really applies here. And I think Section 18 is just a microcosm for the whole bill, in a sense. I mean, it is a special interest provision in a bill that is a special interest bill. And so Section 18 just shows the kind of abuse, frankly, that's gone on in passing this law. And I think all of you should look very seriously at the Rules Committee letter. And if you have any questions afterward, we're happy to answer them. But there are many more things we could talk about. I think at this point I should turn over the microphone to somebody else. Thank you very much for being here.